All right, hey perspectives, welcome to video 2 of the 3-part series, held in my living room, occasional site of philosophy department parties and faculty group meetings, and now the admissions fair talk for 2020. So grab your LaCroix, grab your handout, and I'll make sure Carson posts this online, and we're going to talk a little bit about why knowledge is required for legal proof. So let's just start right off with an example that evidence scholars like a lot. 25 prisoners in a yard, 24 of them get together and gang up and kill the prison guard. And the other one just walks away, not involved. And the only witness is a tower guard far away. Really, the prisoners look pretty identical. They've got the same kind of jumpsuit. Nobody knows which of the 25 prisoners was the innocent one. So the prosecutors take one prisoner at random from the yard and decide to charge him with conspiracy to murder. So they can prove that it's 0.96 likely this person participated in the attack. Like, they can actually justify you in having 0.96 credence that this defendant's guilty. But we don't typically think that kind of merely statistical evidence is really sufficient to find that prisoner guilty of conspiracy and murder. Now compare an example familiar to philosophers. You have a small lottery, 25 tickets in it. You pick some ticket at random and you think, did this ticket lose the lottery? Suppose you just say, yeah, I lost. Seems a little funny about that. I mean, for sure, you're justified in having 0.96 credence that your ticket lost the lottery, but not justified in having just a full outright belief that it lost. Why? Well, in the lottery case, we think that's because you don't know that it lost. Like, after all, 1 in 25 chance that it won. Similarly, in the prisoner's case, 1 in 25 chance that this person's innocent. So you don't know they're guilty. And I claim the reason you can't convict is just this simple similarity. In order to convict someone, you have to know that they did the crime in question. So you might have a couple of thoughts right off the bat about this. Like, hey, wait, you have to know they did it? Like, isn't that setting the bar, like, really high? I mean, knowledge requires certainty, and it seems like, well, you just have to kind of know beyond a reasonable doubt, where that's not quite requiring certainty in order to convict. So you might think, okay, this worry is, oh, well, the knowledge norm of legal proof in a criminal case is just setting too high of a subjective standard, a standard on the subjective state of the fact finder. Really, we should require less than certainty as a subjective state that they have to be in order to convict. Or you might also worry, here's another one, well, knowledge is factive, so if you have to know they're guilty to convict them, that has to mean that you can't correctly convict an innocent person. But surely you can be, like, justified in believing that somebody who just happens to be the victim of some massive government conspiracy, I mean, you can just be justified as a juror in believing that they're guilty and then convicting them and nothing really went wrong, right? Or did it? So some people worry, oh, the knowledge norm imposes an overly strict objective demand, namely truth, on the fact finder. And so I want to just address both of those objections. But first, let me say just a couple more words on, to get around to addressing the objections. I just want to say a couple words about the history of this idea that convicting someone requires proof beyond a reasonable doubt that they did it. Okay, so this reasonable doubt standard, it's been around since the 18th century, so people are really super familiar with it. On the other hand, there's this sense in which it's been completely inscrutable for time immemorial, like since it was introduced. So SCOTUS in 1880 have actually said like, attempts to explain the reasonable doubt standard don't make it any clearer. And there's just a lot of case law on people attempting and failing to explain reasonable doubt. Because it's not like lawyers don't try. I mean, you've got lawyers saying things like, so this is a quote from some trial court. A lawyer says, I kind of like to make it like a football field where you start at one end and you go to the other, and if you go all the way and make a touchdown, that's like 100%. That's beyond no doubt. I like to say reasonable doubt is kind of like 75%. Somewhere 75 and 90. Or here's another quote. This one's from a defense attorney who's actually later found sued for ineffective assistance of counsel, I think, or maybe the case was overturned on those grounds. So the attorney said, well, beyond reasonable doubt, you can tell these are all from American trial court cases, it's beyond the 50-yard line. You have to take it to the opponent's 20, the red zone. You gotta get in the red zone for beyond reasonable doubt. So appellate courts typically condemn analogies like these. They are actually grounds for reversible error. They say, look, the criminal standard of proof cannot be defined in terms of threshold competence. So there's this idea, well, yeah, that's because reasonable doubt means ruling out all the relevant possibilities, but whether a possibility is relevant doesn't supervene on its mere probability. And that's a fact about relevance that philosophers are really used to. So the idea is, look, the reasonable doubt standard was introduced partly in order to make it actually easier for people. You would think it's introduced to make it harder to convict. Really, it was introduced historically to make it a little easier to convict, because way back in the early. So we have a quote here from William Paley. This is on. It's kind of skipping around the handout, but I want to fit into 10 minutes. So 1785, Paley says, "Oh look, like before we got the reasonable doubt standard, what was happening was there was overstrained scrupulousness of juries, which was demanding proof of a prisoner's guilt that the nature of his crime could scarce possibly admit of." Because all these jurors were wrapped up in this kind of moral conscience literature where they thought very sincerely that if they wrongfully convicted an innocent person, they were just going to rot in hell forever. So, understandably, they thought, we're just not going to ever convict. I mean, who wants to take that risk? So they introduced this idea, well, it's actually okay to convict as long as it's just kind of beyond reasonable doubt that the person's guilty, in order to lower the standard. And I would argue in order to make sure that jurors weren't considering just really any shred of doubt in a courtroom, no matter how unreasonable, no matter how fancy. So you get quotes like, an appellate court saying, look, reasonable doubt. So in People v. Davis, is not a flimsy, fanciful, fictitious doubt, which you could raise about anything and everything. Or reasonable doubt isn't just mere possible doubt, because everything relating to human affairs is open to some possible or imaginary doubt. Rather, what's clear is that reasonable doubt means, hey, look, let's be reasonable. And then let's talk about what doubts we consider. And then let's make sure we can rule those out in order to convict. So the idea is this notion of reasonable doubt, what it's trying to do is actually modulate the context that the jurors are deliberating in. It's saying, look, let's not have this absolute ridiculous inflation of our epistemic standards. Let's talk about the kind of doubt that people consider when they're really collating the most important of their affairs. And let's take all, reasonable doubts quite seriously. And that's the key to the idea of the epistemic context we have to be in as jurors when we're deciding, hey, what possibilities do I have to rule out in order to know? So this addresses that first objection. Hey, wait, is the knowledge standard of doubt really so high that we can't possibly meet it? Well, I mean, if you're someone who says, well, wait, I don't think that convicting someone requires knowing that they did it, because it doesn't require certainty that they did it. Okay, what I will give you is, maybe it doesn't require knowing that they did it, but what you did there was you really put a lot of focal stress on the word knows, and thereby raised the relevant standards in our context beyond those that the reasonable doubt standard is trying to get you to have as a juror when you're reasonable and you're in the right context to consider whether you know that someone's guilty and therefore should convict them. So as long as we're really mindful of the kind of pragmatics of knowledge ascriptions, we'll be able to really resolve for ourselves this idea that no, the knowledge standard doesn't impose some kind of really ridiculously strict constraint on a kind of subjective state the fact finder has to be in order to convict. All right, so that's one objection answered, and then I'm just gonna leave the other. Oh wait, is this objectively too harsh? As a cliffhanger, so that's my watch video too if you feel like this is fun. And I'll talk also then more about what legal proof requires not just in criminal cases, which I've been talking about so far, but also in civil cases, so in torts like lawsuits. So